Good afternoon and welcome to HR Quarterly Updates of Pallas Advocaten. My name is Sanne van Ruitenbeek and I'm here together with my colleague Julien Blok. And we are going to discuss updates on legislation, case law and trends relevant for HR. We are here at a studio in stormy weather, so you might hear some wind noises. About the topics we're going to deal with today is, Julien is going to start with the coalition agreement of our new government, the lapse of vacation days, as well as hybrid working after COVID, and working from abroad. I am then going to discuss a presentation about Me Too, transgressive behavior in the workplace, the Gender Balance Act, and employee monitoring. We have a possibility to ask questions via the chat function, so please do if you have any questions. At the end of the webinar, we will, I can read the questions here on this device. If there are any questions which we're not able to answer within the set time frame, we will come back to you about that via email. We have an hour for this webinar, so let's see how far we can come. And Julien, I would like to give the floor to you to start.
Thank you, Sanne. Good afternoon, everyone. As Sanne already mentioned, I'm going to give you an update about, amongst others, the coalition agreement, which has been published on the 15th of December of last year. As you may still can remember, after a period of almost 300 days, the government and the formation of the government, then this coalition agreement has been published. And then, of course, I'm not going to talk about the complete coalition agreement, but only on the relevant parts with regard to labor and employment law. The first thing included in the coalition agreement, and which is interesting, is that it is very specific, that it is based on two separate reports. One from a commission set up by the previous government. It's called the Commission Borstlap. It's not a formal name, but that's how it's called. And a report from the Social and Economic Council of the Netherlands, the SER, which was published at the end of last year. In this coalition agreement, it's also included that the government is planning to have and to implement major labor market reforms, which is of course a big announcement. On the other side, the coalition agreement does not include very specific details on how how they want to reform. More general topics about this, about the plans of the government. So we need to still wait for the more specific plans, laws, which they are planning to implement in the upcoming 4 years, in the upcoming period. But with this announcement of the government to implement major reforms in the labor market and in employment law, one of the questions that I also have is the government intending to amend dismissal law? Because the coalition agreement is based on those reports, and one of those reports includes an advice to amend dismissal law and to include an additional legal ground for termination, so that the employer can go to court, even if there is no reasonable ground for termination. The court can still terminate an employment contract, is the advice. And if the court then terminates the employment contract, there is a penalty for the employer to pay in the advice, in the suggestion from the commission providing that advice. But that is one of the bigger questions. Is the government willing to to further investigate, to implement that change in dismissal. Another part of the coalition agreement includes that the government is willing to reduce the differences between permanent and fixed flexible employment contracts. This is of course something that we hear already for quite some time. More specific, and it also follows from the advice from the Social Economic Council, is that the government intends to take away the period of 6 months waiting period between the chain of contracts. As you may know, at this moment in time, it is possible to agree upon 3 fixed-term contracts within a period of 3 years, and that the chain of contract starts again after a 6-month waiting period. And the government is now intending to remove that 6 months, to force employers and employees to get to an indefinite term contract sooner. One of the other intentions of the government is to increase the minimum wage by stages of 7.5%, and also base the minimum wage on a 36-hour working week. The question that I have is, at what pace is the government intending to increase the minimum wage? And one of the other topics included in the coalition agreement is that they want to disconnect the minimum wage with the elder retirement wage, AOW, which was also a topic in the news over the last week. Furthermore, the government is planning to abolish on-call contracts and zero-hour contracts, and the intention is to replace those contracts by basic contracts with at least a quarterly hour standard. So over a quarter, the employee should work a specific amount of hours, and this is to provide employees further clarity about the hours the employee should work over a fixed period. And again, this also follows from the advice from the Social Economic Council. And last but definitely not least, in the car over, when I was in the car just to go to this studio, it was again also mentioned on the radio. The government is also included that they have that they want to make free a budget of 300 million euros per year to provide a reduction of the burden on tax and social insurances to small and medium-sized companies regarding employees and sick leave. And this is of course a topic already which is already a discussion for quite a long period, because as you know, at this moment in time, as an employer, you are obligated to continue sick pay for a maximum period of 2 years in principle, and it's not that specifically included in the coalition agreement. But again, if you take a look at one of those reports on which the coalition agreement is based on, the advice is, or the suggestion is included to shorten the obligation to continue to pay wages during sickness to a maximum 1 year. So together with the budget mentioned in the coalition agreement, that could be, and the discussion of course, which is already going on for some time, that could be one of the intended major changes in the labor market. And I'm very curious if and when this discussion is going to be continued, and when this discussion becomes more specific, of course, because that would be a major change in the Netherlands for the labor market, and especially for employers. Furthermore, The coalition agreement also includes quite a paragraph or a bullet point regarding employed workers, contractors, or ZZ payers, and the government is intending to end or continue the discussion, which is already taking place also quite some years now already, to further develop an online tool to determine the nature of the employment relationship. This tool was already introduced in the past a few years, but it is all intended to further make it clear in the labor market who is actually genuinely a self-employed worker and who is an employee, considered an employee. And the tool, which is now, which is already introduced, includes several questions which an employer, you as an employer, can include and submit, but also self-employed people can submit the answers in the tool to see if you are, based on the tax authorities, if you are indeed a genuinely self-employed worker. Another topic is that the government is intending to have better enforcement by the tax authorities if there is indeed a employee and employer relationship. Of course, this is already should already be the case, of course, that the enforcement. However, as you may know, the tax authorities already mentioned that enforcement is at this moment suspended, you could say, only when in case of deliberate incorrect self-employment. Then only at this moment, only then enforcement will take place. Lastly, the self-employed person's tax deduction, which is already applicable and which is already being reduced at this moment until 2036 by a 300 euros at this moment. The government is intending to still to increase the deduction to 650 euros annually, so that the tax deduction for self-employed becomes less, and together with the obligation and the intention of the government to introduce a incapacity insurance scheme for self-employers, which would be an obligation, and also of course includes costs for the self-employed. My opinion is that the government is intending to make self-employed less attractive, and employed people who may have an argument that they in fact are employees may start that discussion sooner than currently is the case. That was it about the coalition agreement. Then I want to discuss with you quite a recent court case from the Court of Appeal in The Hague. This court case was published in January of this year, so it's quite new, and is quite. When I was reading it, I thought it was quite funny because it is between a law firm and a lawyer. And includes the discussion started about the termination of the employment contract of this lawyer because he was not willing to work the hours that he needed to work. He was not willing to, and refused to give insight of his workable hours, and was also yelling to colleagues. So therefore, the employer asked the court to terminate his employment contract. That is less relevant for this case, because more relevant for you as well as an employer is that the employee came back with a counteroffer and claimed that the employer needed to pay him his vacation days. And based on the court documents, he claimed in this case 215 vacation days, which were still unused by the employee. Of course, that was not accrued within 1 year. It was accrued, if I'm correct, since 2005. The question was also at the Court of Appeal, have those vacation days, as those vacation days been lapsed, or can the employee still claim all of those vacation days because he never took any vacations? There was not a lot of discussion about the amount of vacation days. The discussion was more, and is also for you more interesting, that the basic rule is that the employer must allow that the employee take their statutory vacation days every year, and the only thing is included in the law, as you may know, that the employee may choose to spend those vacation days within 6 months after the end of the year until the 1st of July. And that after the 1st of July, those vacation days will lapse. However, based on the decision of the court, you as an employer have a very far-reaching duty to take care that the employee, in case, is well informed about the vacation days that he has still has accrued and not used, but also that those vacation days will lapse after the 1st of July, so that the employee is fully aware that he will lose those vacation days. And that was in this case not the case, because the employer never mentioned that to the employee and didn't mention that specifically enough. And even though the employee was a lawyer, which was also one of the arguments, the court was of the opinion that this employer didn't inform the employee sufficiently enough, so the employee was not fully aware what would happen with his vacation days. And therefore the court agrees with the claim of the employee, and the employer needed to pay out mostly all of those vacation days to the employee with the end of the contract. So I think it is important, and as an action point for you to arrange a notification to employees, and a standard notification at the end of each year, informing the employees about the status of their vacation days, but also make it very clear what will happen with those vacation days if they don't take those vacation days in time, to avoid the risk that the employee eventually could claim those vacation days. Then, the last two topics I wanted to discuss with you today is that since last Tuesday, the Netherlands will be open again, based on what we hear from our clients, and I just heard it on the radio also again, and it's expected a trend that most of the employees will continue to work hybrid or start working hybrid and working from home based on a 50-50 situation, but that you as an employer, insofar you didn't already took actions, should be aware that as an employer you have a responsibility still for a safe workplace, also at home, but also, and what we hear from more of our clients, is to take a look at the working from home allowance compared with the travel allowance, which is in most of the cases already agreed upon with the employee, but a working from home allowance is also possible. As I understood, the tax authorities indicated that it is possible to have a structural fixed allowance for employees if an employee works more than 50 days per year from home. Then it is possible to agree upon a fixed home allowance. Another thing is that what we hear from more of our clients is, and of course companies are taking a look at this, let's say new market, is that there are some registration tools available which make it possible for employees to book a workspace at the office, or indicate that they will not come to the office on a certain day. If you want to implement such tools, you need to be aware that the Works Council also, and you have a Works Council of course, also have a position when you want to implement that. The Works Council, for example, has a right of advice regarding new technical technologies, but also a right of consent if this registration system is considered a monitoring system, because you can monitor when an employee is on the office, when he works at home, so you can use that. And last but not least, you also need to take a look at your privacy statement and the privacy impact assessment, how such a tool may affect the employees' privacy, and maybe you need to amend that as well. Then, in addition to the hybrid working, we also still hear a lot that employees are asking questions, struggling with working from abroad, also because of the tight labor market, the battle for talent. A lot of employers and a lot of clients are looking for ways to make their company more attractive for employees to work for them, and a lot of employees nowadays also want to work from another country or from somewhere where it is not raining and stormy all the time. But it is important, and some of the employers also, what we notice, are offering a workation, so that the employee can go for a longer period on a holiday, but also work from their holiday location, so they combine a holiday with work from abroad. With regard to your responsibilities and also watch-outs, we included already some watch-outs in the slides, which you will receive afterwards. But it's good to to be aware of, at least, that any agreements you make, that you record them in writing, that you take a look, is the employee working temporary abroad or permanent, and because that could have an effect on the applicable laws. If you have an employment contract with an employee which is governed by Dutch law, and an employee is going to work permanently from abroad, that could have an impact on which law is applicable on the employment contract, or which laws could be applicable on the contract. Special attention you could pay to, especially if you have a Dutch employment contract, about your reintegration obligations as an employer for a sick employee who is abroad, or when an employee is underperforming, and that also applies, that underperforming when employees solely work from home, and it's always more difficult, especially when an employee works from another country, and how are you going to manage that? How are you going to follow the performance with the employee? You need to take a look at that and be aware of that as well. Then we come to Sanne's part.
Yes, thank you, Julien. Yes, in the second part, I will do my presentation about the transgressive behavior in the workplace, the Gender Balance Act, and employee monitoring. So to start with the first one, I think this topic has been top of mind of a lot of employers these days. We've seen, of course, quite some examples within Ajax and the Voice of Holland, how to deal or not how to deal with these kind of situations. And the question which comes into our practice as well is, okay, sexual harassment, how is that defined and what is not allowed? Because there are also various opinions about that. And it's important to realize that there is a legal definition under Dutch employment laws, and that those laws relate to equal treatment of men and women, actually. And the sexual harassment under this law is understood to be any form of verbal, non-verbal, or physical behavior of a sexual nature, of which the purpose or effect is the violation of a person's dignity, in particular when creating an intimidating, hostile, degrading, humiliating, or offensive environment. And what is particularly important here is the second part, in my opinion, because it refers to that it can be that this behavior of which the purpose or effect is violating a person's dignity. So the effect could also be already sufficient, because what we hear in the cases we have in our practice is that the defense of the person demonstrating this kind of behavior is that it was never his intent or the purpose to violate someone's dignity. But that's not solely relevant if you read this legal definition, because it could still be the effect. And then it could be the effect of the victim having perceived the behavior as such, but also maybe from a more objective point of view, that the employer should assess whether the effect is that a person's dignity is violated. So that is an important topic to take into account. And well, the question is, of course, what should you do with this as an employer? And well, this prohibition of sexual harassment is aimed at those responsible for prevention, and that is also the employer. Reference is also made to the Working Conditions Act, which prescribes that you as an employer should have a policy to prevent psychosocial distress, which includes sexual harassment. So how should you do that? Well, implementing an anti-harassment policy to start with. Most companies do have a code of conduct where reference is often made to anti-harassment. So this could be sufficient, but it's important to check that within your own company, how this is described and whether you think it's sufficient to describes the situation or the unwanted behavior you want to keep out. In that respect, it's also important to implement a complaints procedure. So what should an employee do when he is being harassed sexually by a colleague or a manager? And that such complaint procedure usually also refers to a trusted person, which can be an internal trusted person, but you also see often that external trusted persons are engaged to safeguard a proper process. So what we have experienced that it's important to not wait to do anything with this topic before complaints or until complaints are being filed, because you have a responsibility to act on prevention. And there we see that culture is key in a company. It's important that management leads by example, that there is training or at least active communication on a regular basis about what is unwanted behavior, what qualifies as harassment, and to encourage speaking up. And encourage speaking up is not only about the persons or the victims of sexual harassment, but also about the colleagues who see sexual harassment maybe with another colleague, that they are also encouraged to speak up about that. So that the whole culture is that you fight against this to happen. Giving examples may also be very helpful of what exactly is unwanted behavior, and I will come back to you about that in the next slide. So what we've seen in the public opinion, which is also often followed by courts, is that victim blaming, like she asked for it or he asked for it, is really not done. And there's also little mercy for persons in a position of power who demonstrate sexual harassment. So that will also play a role in the assessment of whether such behavior will result in dismissal or not. Like I've just announced, here are some examples of sexual harassment which we see in code of conducts of multiple of our clients. So we see, for instance, comment on someone's looks, clothing, sexuality, or gender in a derogatory or objectifying manner, or a manner that makes them uncomfortable, or make obscene comments, jokes, or gestures that humiliate or offend someone, invade another person's personal space, inappropriate touching, but also send a display of sexually explicit object or messages, like what happened within Ajax, insinuate, propose, or demand sexual favors of any kind, stalk, intimidate, curse, or threaten another person to goad them to engage in sexual acts. But also the last one, I also think it's interesting what I saw in someone's code of conduct, that flirting with someone at an inappropriate time, like in a team meeting, is considered sexual harassment, even when these advances would have been welcome in a different setting, because such actions can harm the person's professional reputation and expose them to further harassment. So this is also interesting that, there are various ways to look at this, and I think it's important to discuss that within your company. Like, what kind of examples do we want to give our employees that we consider unwanted behavior, and make that clear within your company. So of course we get now these days many questions in our practice, like is this sexual harassment, and can we pursue dismissal? Well, that depends, of course, on the circumstances of the case, but we often see that in case the person demonstrating the sexual harassment has a position of power towards the victim, that it's much more easily accepted that the situation is not sustainable and therefore the managers should leave. This can be an urgent situation and qualify for immediate dismissal for urgent cause. But sometimes the case is not severe enough, or you haven't acted fast enough, and then there is still a route to request the court for cancellation of the contract because of reasonable grounds such as culpable behavior or disturbed employment relation. In these kind of sensitive cases, we of course also see a lot of times that the case will end up in a settlement agreement because of reputation purposes for and the employee and the employer. So that is a solution, of course, which is also quite often happens in these kind of cases. To give some insights on recent case law on this topic, I share with you a court decision of November last year, where 6 female direct reports filed a complaint against a male manager, and some of the complaints even on an anonymous basis. And those complaints relate to remarks about clothing, unwanted touching, implying a functional promotion requires something in return, but also WhatsApp messages with sexual allusions. And this manager was confronted with all these complaints and also the evidence, and he was requested to respond. So you hear both sides you also hear, of course, the side of the person being receiving all those allegations. And after he was heard, the company decided we have enough evidence and objective substantiation to go for instant dismissal for urgent cause. And this was also accepted by the court because of it was considered indeed gross misconduct, and the company acted fast enough to acknowledge the urgency. So, but what about the payments employee could still get in case you're dismissed for sexual harassment? There it's important to refer to a case of the Supreme Court where we see that sexual harassment in a situation of dependency, again, in this case was a teacher and a student, was quite a well-known case about a teacher massaging students quite inappropriately. That was determined that in principle, in that case, seriously culpable behavior is being taken, and therefore no statutory transition payment was due. We do, however, see in lower case law that sometimes courts do grant compensations to people, even though fired for sexual harassment, because of the fact that, for instance, the investigation was not diligent enough, and therefore the employee is compensated for that, which is, of course, important to see what effect that is on practice, because we also sometimes have clients who say, well, if we have to pay a high compensation, if we pursue a termination, that makes them more reluctant to act on sexual harassment. So it's important to see how case law involves there and to assess the effects thereof. So that was it about the sexual harassment topic. I see a lot of questions coming in. I'm not sure whether it's all about this, but I will come back to that at the end of the presentation. Also a bit of a relation to the former topic, this new Gender Balance Act that is introduced by the 1st of January last. This is an introduction of a gender quota for the supervisory boards of listed companies, so beursgenoteerde bedrijven. And it is a quota that at least 1/3 of the males of the supervisory board should be males and 1/3 should be females. So not a full male or full female board in the supervisory board. Another important introduction is that there should be a self-determined target and reporting obligation for large companies to improve the gender balance within the management board, supervisory board, and top management level. So what does this mean? It means that listed companies will have to pay close attention to the appointment of new supervisory board members. And we saw there already a mistake in January of Snow World, who appointed again a male supervisory board member, which appointment was void because of this new law. So it's not yet in the top of mind of every company yet that this law went into force. And large companies, they need to draw up an appropriate and ambitious target plan of action to improve gender balance, and also report about this on a yearly basis if they've met their targets. It refers to large companies, so that's large in the sense of financial reporting obligations. So you should think about companies with a revenue of like over 50 million, so that's really large. So it's not like every company is obliged to do this. Of course, it doesn't mean that companies can still have their own aims and targets to have a gender balanced situation in top positions. So don't forget the Works Council also in this respect, because they have a right of consent in hiring policies, so that also refers to top positions. So if you want to draft any plans in this respect, don't forget to involve the Works Council in that. Then I will deal with employee monitoring and privacy, because we had quite an interesting case of the Court of the Netherlands last December. Because in this case, an employer in the financial services industry requested the court to terminate the employment contract of one of their employees. And the reason for this termination was that the employee performed various side activities during working time without reporting this to the employer. And these side activities relate to leasing of investment property, but also he was a business partner of 2 supermarkets. And he used also the employer's company logo, laptop, and email address for these side activities. So quite serious, I would say. And additionally, there was mortgage fraud for a private individual where he interfered with this mortgage application of a private individual he personally knew. And this mortgage fraud was also filed to the police by the employer. So you would say termination would not be too difficult if you can prove these facts. And these facts were able to be proven because they hired an investigation agency and they started monitoring his email box after receiving 2 signals which were not very clear. But from his email box, they retrieved all these emails which proved their case. However, the court rejected the termination, and that was because the employer could not substantiate that the evidence was produced without violation of privacy rules. There was no clear email and internet monitoring protocol. It was unclear about which legitimate grounds they started with monitoring. They didn't want to share what the exact signals were, as they claimed there was some kind of confidentiality which related to that, which made that the court couldn't assess whether privacy rules were violated or not, and it's up to the employer to prove that. And in this respect, the employer referred to the European Court of Human Rights, which gave some guidelines in 2016 which kind of questions should be taken into account to assess the privacy violation. And those questions are: has the employee been notified by the possibility of monitoring? So is there a protocol in place? What was the extent of the monitoring and the privacy invasion? So was it like an incidental monitoring on a short time, or was it structural monitoring? Were there legitimate reasons to start or continue with such monitoring? Aren't there any less intrusive methods that could have been used? And what are the negative consequences of the monitoring for the employee? And has the employee been provided with adequate safeguards? So those questions should be answered so the court can assess whether privacy has been violated or not. And here we see that that is really important to have this, to safeguard this, because otherwise you can lose a termination case even though you have in fact sufficient evidence. So what do you now need to do as an employer to protect your business and therefore to win these kind of court cases, because you cannot tolerate the behavior, of course. Well, it's important in that respect to draft a monitoring protocol to implement this if you don't have it yet, and take into account as well what the Dutch Data Protection Authority thinks about this. They also have some guidelines available, again referring to legitimate interest. It should be necessary to serve that purpose of legitimate interest, to notify the employee, again the protocol, and also respect the right to confidential communication, because it's not accepted anymore that the mailbox of an employee, even though at the company is unconditionally accessible by the employer. There is a right of confidential communication also by means of company communication channels like mail or Slack or anything like that. So what should you put in such a monitoring protocol? You should inform the employee about what kind of data will be monitored, monitoring for what purpose, and monitoring to what extent. Is it incidentally or structurally? And who has access to the personal data obtained via the monitoring? Is that like whole HR or IT or an audit team? And who is authorized to access, or how is unauthorized access controlled? So what's the safety? What are the safety measures? And how long will the data be stored? So if you start with such a protocol, it's important to take these questions into account and to do a privacy assessment on that as well. And we see that there's also a relation with the former topic on the code of conduct or the anti-harassment policy, because the monitoring of mailboxes is also used in this respect. So that can be a legitimate purpose to monitor an employee's mailbox, but you should inform employees about that in advance. And also, in relation to this topic, be aware that the Works Council has a right of consent about such monitoring protocol, because it is a regulation about processing of data, and it's also a regulation aimed at monitoring of employees' behavior. So again, there, don't forget to involve the Works Council if you implement such monitoring protocol. I will end with the key actions from both of our presentations, and we'll then go to the questions. So what is, of course, to start with important is to follow the updates on new legislation under the coalition agreement. So there's quite something to come. Of course, we will support you with those updates. It's important to send employees yearly notification about the risk of holiday lapse, at least if it's in your company, the situation that employees have a lot of holidays, which they don't always take. It's important to update employment contracts or your manuals about working from home, the travel allowance versus the home allowance, and to implement or activate your code of conduct or anti-harassment policy and complaints procedure to put that in top of mind of your staff again. And to observe the gender balance requirements in at least top positions, to implement an employee monitoring protocol, and to involve the Works Council in 4 of these steps. So those are the key takeaways of this presentation. Then I will go to the questions now. Let me see what comes in. I will start with this question. Is it enough that you use a global code of conduct policies and whistleblower systems for your local entity? And can you refer to that? Or do you need to have a specific information for the specific entity alone? So the question is, can we use a global code of conduct, or should we tailor-make it for your legal entity? In principle, a global code of conduct can be sufficient, because sometimes maybe culture in a specific country may play a role. You may want to tailor-made your examples for that local sub. But you could say that a global code of conduct can be used. It's not, from a legal perspective, required to have a specific local code of conduct. So I hope that answers the question. I see now a follow-up question. I mean, because the employees or the representative didn't approve officially. No, so I think the question is, do they need to sign? Does everyone need to sign for the code of conduct? Well, preferably, of course, yes. From a legal position, we would like everyone to sign for everything. But if it's clear that you communicated the code of conduct and send it to everyone, and you can prove that also at a later stage than before hiring the employee, then then it's still okay, because as an employer, you have the right of giving these instructions. So it's okay to do that also later than in the start of hiring employees. Let me see here. What if a company has more than 50 employees and you do not have a works council? How will it work then implementing policies? Will the policies not be viable? No, they're still viable. It's not like you have no works council, so you cannot have a policy. So then you can implement a policy without involvement of the works council. It could, of course, be a reason for employees to step up that they want a works council when you start doing things like that, but it's not void or anything because you don't have a works council.
Yeah, so it could trigger the start of a discussion too.
Yeah, it could indeed trigger.
Works council, yeah.
And still, even if you don't have a works council, you could maybe still consider starting or organizing some kind of employee body, maybe more informal, to discuss this topic and to see whether you can have some support from the working floor in your policy as well. So not only top down, but there can be, of course, employee involvement organized also in another way. Let me see here. We would like to source an online training that we can have all our employees attend and issue to new hires on joining, and also refresh every couple of years. Are you aware of any organizations that offer this that you would be able to share? I'm not sure if this relates to also the harassment and code of conduct, but that's what I think, if I see the timing when the question was submitted. So the question is, if
are there any companies who provide such training about the what is done and not done within the organization?
Yeah. So there are indeed companies who train on code of conduct standards, for instance. We also sometimes support with that. But maybe if you send us an email, you see our email addresses now on a slide, we can support you with referring you to a company that could support with that.
Yeah.
Then I see another question. To what extent is the employer still responsible for the reintegration of a sick employee that works abroad?
Yeah, if you have a Dutch employment contract applicable and the employee is employed, let's say, by the Dutch entity, then still you have the responsibility to reintegrate the employee even though he's abroad. So what we see a lot is that if there is an agreement that an employee can work abroad for a significant time, that part of that agreement is that when the employee becomes sick for, let's say, a longer period than 1 week, 2 weeks, 3 weeks, whatever you like, that the employee is obligated to repatriate back to the Netherlands. So in that case, you can fulfill your reintegration obligations. Also, because it is quite difficult to get abroad to get a physician on the same level of a company doctor, and you still need to have the advice from a company doctor to determine if an employee is indeed not capable to work. And the risk is, if you do not follow all the steps, as you may know, applicable from the UWV during those 2 years, if there is of course a case of long-term illness, you have the risk of a penalty as an employer. So therefore it's important to make very clear arrangements that when the employee becomes sick, and sick for a longer period of time, that he needs to go back to the Netherlands.
Okay, thank you. Another question for you. Is the online tool of the tax authority about contractors, the self-employed workers, already accessible?
Yeah, the definite tool is not accessible. Was never accessible. There is a pre-tool, and that was already accessible 2 years ago, 3 years ago, quite some time ago, and it's still accessible. And you can find it on the internet, of course. And the most easiest way is to find it through the Dutch Chamber of Commerce. They have a very clear link to the tool.
So if you want to know what kind of questions will be asked in such online tool to determine whether you're dealing with a self-employed worker or actually an employee, you can already look at it, because it will already give some clarity on the type of questions that need to be answered. Yeah. Okay, another question for you. The 6-month period between temporary contracts will disappear under the coalition agreement, or that is expected. So will then also not be possible to hire an employee on a temporary contract, like after 10 years that he left?
Yeah, that's a good question. And indeed, it is the intention from the government to implement that rule, that it will not be possible, the 6 months will not be applicable anymore. If it will be possible to hire somebody after 10 years, after he or she already had 3 contracts, the answer is, I don't know, because it's still vague in the coalition agreement. It's not mentioned in the coalition agreement how they will implement that. And also, I also looked at the advice behind the coalition agreement, and it's only mentioned there on a side note that a certain period should be included, but not how long and what. But Yeah.
Okay, so we do expect some time frame.
Yeah, but what it will be is still the question.
Yeah.
And
it's probably longer than 6 months.
yeah, most likely.
So it will be less attractive to have this situation of
That's the whole purpose.
Eliminating the contract and then restarting it. Okay, well, those were the questions on this list. So I think we come quite within our time frame to the end of this webinar. Thank you very much for joining. It was great to do this again. Much better if we would see you live again later this year as well. We will have a new webinar again probably in June, an HR Quarterly update, but also some live events will be coming. So keep your invites, keep your mailbox in sight for our invites. And thank you very much for watching, and we'll see you next time. Thank you. Bye.